Welcome back. We're going to talk about all of it today. Huge updates in the YSL Young Thug RICO trial out of Georgia. So let's go. I'm legal analyst Emily D. Baker. This is the Quick Bits, where I break down just the main points of the pop culture and entertainment cases I'm currently covering on YouTube and the Emily Show podcast. Let's get into it. You may remember the last time I covered the Young Thug YSL RICO trial out of Georgia. We talked about what was going on with the judge and this ex parte, which is a in-chambers closed-door meeting that the defense attorneys weren't a part of. One of the witnesses, witness Copeland, was in chambers with the judge, the DA, his own attorney, and others. The attorney, Brian Steele, who is the attorney for Young Thug, which is his stage name. Jeffrey Williams is his given name, but we're going to go with stage name. It's the Young Thug trial. That is how we know him. His attorney, Brian Steele, brought it to the court's attention that he was aware of this ex parte hearing. The judge then says, basically, name them. How do you know who told you? Brian Steele wouldn't state that on the record or at all, saying that it was part of his work product in representing his client and that he wasn't going to disclose it at all. The judge held him in immediate contempt of court and had the bailiffs take him into custody and sentenced him to 20 days in custody to be served on the weekends during this murder trial. Remember, it took 11 months to pick a jury in this case. Jury selection started in January 2023 and went through November 2023. And then this trial started in December 2023. It's July 2024. And this trial is now indefinitely on hold. And there have been breaks before. There have been issues with other defense attorneys. There was a medical issue with one of the defendants who was attacked in custody and needed to recover. There have been huge pauses in this trial. I don't know how this jury is doing this, but this jury is still the jury in the case, even though testimony has been indefinitely paused. Here's why. Defense attorney Brian Steele filed a whole bunch of motions, some to the Georgia Supreme Court, appellate court, and then at the state level court. The Supreme Court gave him a stay, essentially, of having to serve his custody sentence and issued a bond so he doesn't have to go into custody until this entire issue is resolved. The appellate court essentially said, you need to make motions in the lower court to have the judge recuse himself, and then you can appeal the rulings on that. And that's exactly what was done. And I covered that briefly. The motions from Attorney Steele saying, look, Judge Glanville, you can't do this anymore. You are conflicted on this case. There is bias here and you need to recuse yourself. What happens if this trial judge recuses himself? I think at this point, it has to be a mistrial. And I don't say that lightly. This case has been extensive. We're 18 months plus into this case. A mistrial at this point is a huge waste of time and resources. But when we're looking at the witness, Copeland, who had the ex parte hearing, that witness continued to testify after that ex parte, even after defense raised issues about it. And I don't know if you can unring that bell. Even if that witness is brought back to the stand to be cross-examined with what the defense attorneys now know, I don't know if that fixes it. And I don't think there's any way around this case being a mistrial having to go again, which there are 7 defendants here. There are over 26 or 27 defendants total in this RICO charge. There are multiple prosecutions stacked behind each other in this case. So a mistrial here would be devastating. But the defendants have inalienable constitutional rights. And if those rights are violated, there's no other remedy for them. You can't just keep going forward when they're asking for the judge to be recused in a mistrial. There's no other way around it. So the judge made a bit of an about face on Monday, July 1st, the same day that the Karen Reed jury ended up coming back as deadlocked. And on Monday, the judge indicated that he is going to actually send the motions for recusal to another judge to determine, which is the proper thing to happen here. Another judge should have also heard the contempt proceedings, but that ship has kind of sailed. The motions to disqualify this judge or to have this judge recused need to be heard, and they are going to be heard by another judge. That's the proper result. And the judge released the entire transcript to the defense, and now it is public because it's court record, of the hearing in chambers. Did I think it was going to be worse than what we'd heard? No. Is it? Yes. So this hearing took place with quite a few people in chambers and took place in chambers before the witness even came in. So the hearing started with the judge, Assistant DA Love, Attorney Bumpus, the court reporter, and 2 investigators for the DA's office. And at the beginning of that, the DA went through what they were concerned about and the testimony of Mr. Copeland and giving Mr. Copeland immunity, and talked about the fact that initially when the DA was emailing back and forth with Copeland's attorney forwarded along to other defense attorneys, Steele and another defense attorney, who are representing defendants in the Young Thug case. So the defense attorney for witness Copeland is sharing the conversation between themselves and the DA with other defense attorneys on the case. And that very much pissed off the DA in this case. Before they even bring Copeland in, the DA is telling the judge about this issue. And the DA said in this hearing, whose interests are you protecting? And this is the DA responding to Copeland's attorney. The DA responded to that email saying, whose interest are you protecting? Yours or Mr. Steele's? Whose clients? Which client are you protecting? Whose client? Yours or Mr. Steele's? He wrote back and said, quote, you are going to get him killed. This is Copeland's attorney talking about Copeland. You are making him a target. Fuck you. So there's no love lost between Copeland's attorney and the DA, because the DA is forcing Copeland to testify and giving him immunity. And his defense attorney is saying he's not going to testify. And in fact, when Copeland took the stand, he said, I'm not a snitch, and tried to plead the fifth, even though they had granted him immunity to overcome that. He's like, I'm not saying anything, which in a case with gang allegations isn't a shock and shouldn't be a surprise to the DA that this witness doesn't want to testify. So this context, when the witness then comes into chambers and says, fine, I'll just lie. I'll go on the stand and lie. I'll take responsibility. I'll say I killed people. I'll just say it was me. You're going to give me immunity? I'll just say it was me. The defense needs to know that. If a witness is telling the judge and the DA, if you put me on the stand, I'm going to lie. And if I lie, I'm going to take responsibility for everything because you already gave me immunity. So I'll just take responsibility for all the stuff. You gave me immunity and whatever. Or I'll take the fifth and you can't force me to testify, or I'll just sit in jail. And then when Copeland came in to talk to them, he said, fuck you guys. You know what you're doing. You know it's my kid's birthday coming up. But if you want to put me in custody, fuck you. Put me in custody. I don't care. I'm not saying shit. And it goes on and on and on. This is a much longer ex parte than I anticipated it being. And they didn't just talk about scheduling. They didn't just talk about the witness being afraid. Having a conversation about the witness being afraid and needing protective custody and how that practically would work wouldn't be the most inappropriate ex parte. There are ways that if you don't talk about the case and say, this is how we're protecting you, this is what that use of immunity or grant of immunity encompasses. Your attorney can talk to you about it when we're out of the room. This is how we're going to offer you protection. What are you afraid of? Those conversations without talking about the substance of the case, the substance of the testimony may be okay in some circumstances, but talking about what you're going to testify to or not testify to, talking about the substance of the case, talking about the facts of the case, none of that is appropriate for an ex parte communication. And what the DA's offered or promised is all stuff that has to be disclosed to the defense because they can cross-examine this witness on it. He gets up and testified and they're like, you told the DAs you were going to lie, didn't you? Yeah. And they still put you on the stand. Yeah. Did you lie? Yeah. Like the defense needs to know that so they can cross-examine this witness. Again, the DA should know this, but the judge also knows this. This is not a proper conversation to be had ex parte. The conversation about fear and safety, sure. But once we get into the nature of the testimony, there's no way that that should have been ex parte. And there's no way that when it was brought to the court's attention, the judge's response should have been, who told you? This transcript should have been made available. This ex parte never should have happened. And I think that when another judge looks at this, they're going to recuse the judge. In part of this hearing, the judge is telling the attorney what the attorney needs to say to their client. The court says, quote, and I think part of his challenge, Ms. Bumpus, Copeland's attorney, maybe that you need to assure him, quote, look, I'm going to be here. And if you think that they are asking you a question, end quote, they being the state or the defense, quote, is asking a question that's going to bring out other crimes that he's going to be able to look at you and say, can I have a chance to talk with you? And the DA said, that's exactly right. So now they're telling the attorney what to tell the client. And then the DA says, that's exactly right. And the defense attorney goes, And the DA says, see, but that's just it. And the defense attorney says, no, he's not. And the DA says, hold on. That's just it, Judge. The problem is that there's been an assertion that people are representing, and I'm not talking about you. And the defense attorney says, yeah. And the DA goes on to say, there's been an assertion that people are representing that their biggest concern is his best interest, and then they're just not here. And Ms. Bumpus is saying she's not in a position to do that. Bumpus is not Copeland's regular attorney. Copeland's regular attorney is on vacation the week that this is all going down. And he's supposed to be granted immunity and protection and testify and be forced to testify or stay in jail for years. And when they told him he would stay in jail for years, they said for years until all the prosecutions are done. And Bumpus goes on to say, no, I'm not saying I'm not in a position. I'm saying that the agreement between Mr. Copeland and the other attorney who I'm standing in for is that if he chooses to testify, I'm to get him to sign this paper that says that then discharges the other attorney as his rep. That's their agreement. I can't do nothing about that. And so now there's this whole other issue going on about whether or not this witness Copeland is also changing lawyers in the midst of this agreement for immunity. And the DA is like, what are you even talking about? But all of this gets into talking about this witness's testimony. So when we're looking at what's going to happen next, another judge is going to hear the motions to disqualify and to recuse Judge Glanville. If that happens, that motion also asks for a mistrial. And I can't imagine if they're removing the judge after 18 months, after this ex parte conversation happened and after this witness continued to testify, that anything happens other than a mistrial. So I'm going to be keeping an eye on this even as we get underway in Baldwin. But for now, the Young Thug trial is on pause. And will it be taken off pause like a housewife hoping to get onto Traitors? I don't know. I don't see any other way around this, and I will be very interested in how the courts handle it. But it seems that even if the courts don't declare a mistrial and there is a conviction at the end of this trial, that the issues for appeal are so hopelessly stacked up that this case really won't actually have a conviction of anything, because on appeal, all of this will be rehashed again. And I truly don't see a way around it. But I'm not an appellate judge, so we will see. That ex parte is a huge problem. And allowing that witness to continue testifying while the issue of the defense attorney for Young Thug's contempt is still standing is a problem. Hopefully that all made sense. I'm baffled by what has happened in the Young Thug trial. Truly and honestly baffled and a bit horrified. This never should have happened. And the defense attorney who disclosed it to Young Thug's attorneys and others, I think, was doing ethically what they thought was right, because they knew that this ex parte never should have happened this way either. And it seems that that's exactly how this was disclosed, because the judge in his hearing on Monday said that he had seen footage from the courthouse hallway where this attorney is talking to Attorney Steele. So the judge knew exactly how all this went down. And I think was mad that anyone would dare talk about what happened in chambers. But when what happens in chambers is wrong, it should be discussed and it should be brought to light. And we will see what another judge thinks of all of this. I hope it gets sent to a different courthouse. Judge Glanville is the site judge of his courthouse. And we will see how all of this goes. So hopefully the recap today was helpful. So with all of that, thank you for being here. Thank you for being a Law Nerd. Don't forget to get the Law Nerd app, and I will see you in the next one. For deep dives into the stories that I covered here, you can find them on my YouTube channel at The Emily D. Baker and The Emily Show podcast. I stream every Tuesday and Thursday. The podcast goes live on Wednesdays. And if you want to stay in the loop with everything I'm doing, receive the fastest notifications out there, and get more Law Nerd community, join me at lawnerdapp.com, our free app for iOS and Android.